Welcome to Employment Law This Week. I'm George Whipple. Our top story, the D.C. Circuit endorses the NLRB standard for micro-bargaining units. The board applies the specialty healthcare test to determine whether a group of employees are an appropriate bargaining unit or if other job classifications must also be included. A theatrical staging company recently challenged both the test and its application, arguing that their equipment riggers should not have been allowed to organize a micro-unit. The D.C. Circuit upheld the board's ruling that the riggers' micro-unit was appropriate and that other workers did not share an overwhelming community of interest with them. The D.C. Circuit found that the board's standard is consistent with the Act and that the board did not exceed its authority in adopting it. Pat Wheeler has more.
For employers holding out hope that the D.C. Circuit was going to turn the tide on the specialty healthcare test, the Rhino decision is indeed a setback. And now the most likely way that change will come will be from the board itself. And likely that will happen once a Republican majority is in place, which should be sometime this year. In fact, it's notable that on May 10th, NLRB chairman Phil Miscamara issued a dissent to the Crystal case, in which he explicitly stated he believed specialty healthcare was wrongly decided. And Miscamara noted in that dissent that the micro-unit certified in Crystal was a unit he did not believe was an appropriate unit because it promotes instability by creating a fractured or fragmented unit.
Electronic acknowledgement of an arbitration policy does not imply agreement in New Jersey. A state appeals court reinstated the age discrimination lawsuit of a former Best Buy worker, concluding that he was not required to arbitrate his claims. The company implemented an arbitration policy 3 weeks before the plaintiff's termination, and he clicked an electronic box labeled, "I acknowledge." The New Jersey Appellate Division held that neither the plaintiff's acknowledgement that he received the policy nor his continued employment demonstrated that he agreed to the policy's terms. Pressure from courts to compel website accessibility is building. New York art supply store Blick, which sells some products and services exclusively online, was brought to court on charges that its website was not fully accessible to the visually impaired. Blick filed a motion to dismiss, arguing that the Americans with Disabilities Act does not apply to online-only businesses. The district court denied the motion in an expansive decision. But in a troubling development for the online-only businesses, the court in this case joined a select few in holding that the ADA covers all retail websites, not just those connected to a brick-and-mortar store. A Connecticut district court finds that federal law does not preempt the state's medical marijuana law. Before undergoing a routine drug test, a Connecticut nursing home employee disclosed to her employer that she was prescribed medical marijuana at night for PTSD. The employer rescinded her job offer after she tested positive for marijuana. Connecticut's Palliative Use of Marijuana Act prohibits employment discrimination solely on the basis that the employee is a medical marijuana user. The Connecticut District Court ruled that federal law does not preempt the state employment law in this instance. Finally, it's time for our tip of the week. Marie Cherie, Senior Vice President of Human Resources for Mizuho Americas, is here with some advice on HR's role in successfully managing change.
First and foremost, secure the total buy-in, support, drive, visibility, and leadership on an ongoing basis from your senior management. Create a project plan with clear goals, milestones, deliverables, accountabilities, as well as action plans. Determine how you will measure your progress so that you can course correct at any point in time. Make sure you get the buy-in from your line managers and provide them with the tools and resources they need to lead the change at the team level. Don't forget your employees. Always treat them the way you would like to be treated, with dignity, courtesy, and respect, as this will help maintain the engagement.
Thanks, Marie. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.